Hello, friends. In continuation with the branding sessions that we've been having, uh, again, the same friend who had requested the naming process has requested that I give them some idea about trademark registration, why, how. So today's session, it's not my domain knowledge. I don't have domain knowledge in this. Whatever I'm speaking today is predominantly from research that I did on Google and talking to two people. I was hoping to talk to one of the experts in trademarking who was recommended, but that didn't happen. And I talked to two other people, and this is a summary of what I understood out of those conversations and my Google research. So let's start, and I'll start sharing my screen. So, as I said, we're going to talk about what a trademark is and what is the application process for the same. So, let's get on with it. What is a trademark? A trademark can be anything that is unique. It can be a name, it can be a phrase, it can be a logo, it can even be a sound bite. Okay, so any of these things can be registered as a trademark. And essential to registering a trademark is that it must be unique. It cannot be used or has been used by somebody else, then you cannot get it. It has to be unique. Naturally, since you are registering the trademark for a brand, it has to be something that will also identify the brand in a unique way. And this will then distinguish it from the other trademarks, especially those of competitors. Okay, so you cannot use a trademark that is similar to something that anybody else is using, and especially within your space. It's not good for them, it's not good for you. Okay, because you become a copier. You're not original. That's not a great thing for a brand. And you're trying to ride on someone else. So it's not good. For that person, it is not good because he'll probably get into litigation with you and suing you for using his trademark or something that's very close and can be mistaken as his. Okay. A trademark can be registered for a product or a service. It doesn't only have to be a product. It can be a service you're offering, and you can still get a trademark for it. And once your trademark is registered, nobody else can use it without your explicit permission and approval. So you become the owner of that particular mark, whatever it is. It's a name, a phrase, a logo, a sound, or a combination of this. It can be a logo and a name. Okay, but then you have to register both of them. Sometimes you coin a word which you feel that people might want to copy, and that word means a lot. You register the word, the name that you have coined, as well as the logo that you designed. So both those things need to be then trademarked. Okay. So what are the different kinds of trademarks? We've been talking about trademark, and I mentioned word and I mentioned the logo. So what are the different kinds of trademarks that one can apply for? One is a word mark. It is a set of characters that distinguish the company, either its product and or its service. And examples of this are, say, Facebook and Nestle. Okay, Nestle is not a normal English word. It's been coined by using. So Nestle as a word can be the same. And the Nestle is written in a particular format. That whole format, which essentially is the logo, can also be registered. The same thing with Facebook. Facebook is a word that has been coined. That can be registered. Nobody else can use the word Facebook. And the way it is written, which is again the logo for Facebook, can also be registered. You can register more than one logo. So you can have Facebook completely written. At times they want to just use FNB. That also can be registered so that it cannot be copied by anybody else. Then there is the service mark. A service mark is used to differentiate different companies that are offering the same service. So say FedEx. Okay, so there are so many companies that offer that kind of a courier service. But FedEx has registered its name and brand in that particular way so that it distinguishes itself from all the others who are in that space. And of course, there are logo symbols. Generally, logo symbols are symbols that are used without adding any word to it. Just seeing that logo will tell you about the brand. And one of the best examples, which everybody will immediately recognize, is the apple. That apple with a small bite taken off. You see it and you know what product they're talking of, what their USPs are, what are they known for, everything else that goes with it. Then we have shapes. So if you are doing something or using some packaging that has a unique shape, you can brand that shape so that nobody else can copy the same shape of the bottle. Okay, and the example of this is the Coca-Cola bottle. Nobody else can use it as it is with the ribs. The general shape may be used, but they cannot have the ribs. So identical to the Coke bottle, nothing is allowed. Then you have the series mark. So that is something that is used for many products by a company across various this thing, and it is identifying and it's telling you that, okay, that product is from that company. And an example of this is the word Mac. McDonald's has a Mac burger and a Mac chips and whatever else that you can, and it is all beginning with Mac. It's a prefix that they use for most of their product. A burger is known, but Mac burger makes it unique. The minute somebody tells you I've got a Mac burger, you know it's from McDonald's and that it's a burger. In the same way, the alphabet I before Apple products, you have an iPhone and an iPod. That I, once you see an iPhone, you know it's an Apple phone. So these are common prefixes. There can be some suffix. I have not been able to think of any suffix, but it can be a suffix also. And then there's a collective mark. What do you mean by a collective mark? When a group of people who belong to a certain category, okay, and the example I'm giving is chartered accountants. And if you know, they have that logo with a CA, okay, which tells you that, okay, this is a chartered. Once you have got that logo anywhere, you know that a chartered accountant is involved, and it makes it unique, and it tells you that he belongs to a certain group, and which is a group of chartered accountants. And then you have the certification mark. This we all know of. A lot of companies now are using it as standard thing. It is somebody defines a set of criteria under which your product or service has to adhere to. Those criteria are necessary for your service or product to adhere to. It may be a manufacturing process. It may be various things. Okay. And you have to, if you want to use that logo, you have to follow certain guidelines and principles as set by the people who own that logo. And an example of this is the ISO or the FSSAI. Okay. These, once you see an FSSAI mark on any food product that you are buying, you know that this is going to be a minimum quality of a minimum purity, and that the quantity you are getting is great. Then you have the sound mark. As I said, you can also register a sound as a trademark. And the sound mark is when you use specific sounds or tunes that distinguish the brand in a unique way. Anybody who listens to that sound or tune will know. There are so many brands that use this. And the one that is, I think, top of the mind recall, at least for people of my age, when the only thing you were able to watch on TV was Doordarshan. You hear that sound and Doordarshan comes to mind. Even today, when I hear that sound, I say, oh, am I going to see Doordarshan now? Okay. Now, we've said of what kind of brand. So you have to decide. As I said, you might need to register for more than one of the categories, like a Facebook or like a Apple. Apple has the logo also registered. Apple has the eye also registered. So there are various things you'll have to go in for multiple branding, but it's all worth it, trust me. Now, who can apply for a brand? That is also important. And the first category of people who can apply are individuals. I can go apply for a brand or anything I want, whether I'm in the business or not. Even if I'm not doing that work right now, I can. And I think if you Google, you might come across people smart enough to register a brand for some company, upcoming company. And then when that company has come up and they want to register that, they can't. So they have to buy the brand from you. Yes, you can transfer your brand rights. So even if you're not in the business or a service provider, you can register and it can be used in the future at any time. Supposing today, or maybe 5 years back, if I thought of Thought Shots and I'd registered this logo, I could use it now and there's nothing to stop me. Yes, the validity period has to be looked into, the renewal needs to be done, but it can be used at any time in the future. And then there are joint owners. Okay, now these joint owners is the same as an individual. It's just that there are more than one owner of the brand. So it can be a group of two or more. Similar to individuals, but can be two or more. Then we have proprietorship firms. Any firm, whether proprietary, partnership, limited, can register. It is generally registered under the firm's name. But a lot of proprietary firms you will find bear the name of the proprietor himself. Now, in such a case, if that proprietor firm is a registered firm, then the logo will be in the name of the firm. So if that individual also wants it on his name, then it is a question of making two applications, one for the firm and one for his personal name. Okay, so two separate filings will be required in such a case. Partnership firms, again, as I said, it's any firm can get this thing, but in such a situation, the registration is in the name of the firm and the individual partners do not individually claim any right to it. Okay, this is very important. We see a lot of partnerships splitting up, but both partners cannot use the same logo. To give you an example of this, say Reliance. When the brothers split up, Anil Ambani had to go and make a different logo for himself because the original company's logo was with Mukesh Ambani. And then limited in partnership, limited liability, but absolutely the same. It's just that the definition of a LLP is that each partner has a limited liability. So it's absolutely similar. And then, as I said, you have Indian companies, which can be either private limited companies or public limited companies. All of these can register a logo, but in their own name, in the name of the company, sorry. Foreign companies, same as Indian companies, they can register a logo anytime they want, but the company should be a corporation, a registered corporation. A foreign company that is a partnership cannot register a logo in India. They would need to get incorporated first. As a partnership, no problem, but they need a corporation. So registration is in the name of the company and it must be a registered corporate. Any trust or society can register a logo. Okay, so when you apply as a trust or society, the application should be done in the name of, as representing the society, in the name of either the chairman, the secretary, or the managing trustee of that trust or society. Okay, the logo will be owned by the trust or society, but you need somebody who's going to sign it. Like in a limited company or something, it's easy because there are directors who will sign it, or there's a CEO who will sign it. So it's not critical. Here, the reason for mentioning this is that the law very specifically states that it can only be the chairman, the secretary, or the managing trustee who can sign the application. So now that we know who can make an application, the next question that automatically comes to mind is what are the benefits of a trademark registration? So the first and most important benefit is that it prevents competitors from using your credentials, your name, your logo, anything similar to that without your the thing to boost their sales. They cannot do it. So it makes you safe in the space that you're working. And it gives you recognition. A logo which is well known, well publicized, people will see the logo and recognize it. You see certain logos and you know, oh, this is this company. And there are plenty of them. I don't even know where to start. Okay, in India, if you look at the Tatas or if you look at the R of Reliance, like that R with that drop kind of thing, you also know that anybody who puts in a little more effort will know, oh, they're drops, so it's a drop of oil kind of thing. So it gives you recognition and it distinguishes you from the competition. Okay, once you say Tata Salt, you know that there are USPs of the Tata brand that will come with that product, and therefore it distinguishes you from the other salts in the market. And it gives credibility because every brand, every registered brand has its own USPs, which are defined. And those USPs are defined to make you distinctly different and superior or better, let us say, in many ways compared to the competition. So once those USPs are ingrained in the mind of the consumer, that brand name automatically tells you of what to expect and it gives you credibility. And as I said, every brand, they set up their own this thing. So automatically it guarantees. So the minute I buy something from Tata, I would not agree with it today. They are slipping in a lot of areas. But once you use the name Tata, certain level of service, certain quality of product and service is automatically assumed. So having said all this, I think you know most about the branding and why it is required to be done. I think now we just first to talk about the trademark registration process. And then we'll take a quick look at what are the documents required for a registration. So what is the trademark registration process? First is an in-house process that you need to do yourself. You need to research and find out whether something similar is already been given a registration as a trademark. Because if it is already done, your applying is only going to end up in a rejection. So it doesn't make sense. And you don't want, as I said, you don't want to do it. You want to be unique in your own way. And you want to then tell people about your USPs. So you don't want a confusion with any other brand. So there has to be a trademark search, which is an in-house, your own effort. And once you have done that and you're convinced that, okay, it is unique, then you have to file an application for a trademark registration. And that application form in India is called the TMA form. So you have to fill this up and submit it. Now, once you submit a registration, along with the name or the logo, you can use the small alphabets TM at the top right-hand corner of that whole image. TM does not mean that the trademark is yours yet. It only means that you have applied for the trademark. So now when an application is processed, it is also the first in, first out. So if you are putting a TM and then anybody who is doing research sees that, okay, your name is similar, but you already are putting the TM mark, okay, they know that, okay, they are not going to get it. So they need to start looking for something else. So you can use the TM mark. And by the way, if you use the TM mark without having an application, it's an illegal thing to do. You can be prosecuted. Okay. Now, once you have submitted your application, what you did on your own is now done by the authorities. So the government starts scrutinizing your application and checking whether everything that you have given is unique. And if they notice that there is a conflict, they will come back to you and you will need to resolve that conflict by giving proper explanations and proper details of what is the difference or how that conflict is not a valid conflict. So you will need to respond with details and or explanations. And then this process is an iteration process. Okay, it can happen once, it can happen twice, it can happen 4 times because the authorities are not convinced. So this iteration process will go on, and at some stage, the authorities will tell you, okay, sorry, we've had enough of this. Your application is rejected. Because if your explanations are not convincing, if the details you give are not convincing and do not justify the objection, okay, then they will reject it. Or at some stage, they will say, okay, now we are convinced and we accept it. Now, once they say accept it, what they will do is that they will publish the details of your trademark, whether it's the logo, whether it's the name, whatever, in what is known as a trademark journal. Now, this trademark journal, which is published, is open to the public. So any other person, whether it's an individual, a company, or anybody else, can see your trademark registration application, what you have applied for, the logo, the form, the soundbite, whatever it is, and they can raise an objection if they feel that you are infringing on their trademark in any way whatsoever. So the government has done its job. Now it is open to the public. So anybody can go and raise an objection. And if any objection is received, it is like the first government objection, scrutiny objection. They will ask you to justify it and to explain it. At times, if the explanation is not valid enough, they will ask or they will tell you to come for a hearing where they will hear you out, because so at times, you cannot completely describe accurately something in writing. So then they will call you for a hearing where they will hear you out. The person who has raised the objection may also or will generally be present. He can counter you on the live. And so this saves time of going back and forth. Okay. So it can involve this thing. And upon resolution of that objection, once that objection has been clarified, cleared, then it will again be published in the TM journal. Again, it's a reiteration process till no other objection is this. And once everything is clear and nobody has raised an objection, then the trademark is registered. Now you are the official owner, legal owner of that trademark that you, whatever it is that you had applied for. Now, when a trademark is registered, the normal validity is 5 years. And you need to keep renewing it. It can be renewed as many times as you want. There is no limit on that. But the normal first registration you will get is for 5 years. And once your trademark is registered, if you notice on a lot, next to a lot of logos or names, there is a R in a circle, which is there again, where the TM used to be, it comes an R in a circle on the top right-hand corner of that. This tells the people, this tells everybody that you are already a registered trademark, not just applied, you have been given it. It has been allotted to you, and you can claim ownership of that trademark. So now, I think this is the last part of it. What are the documents you are? This may not be exhaustive. You will need to consult with a trademark consultant or maybe go to the trademark office and find out the exact details of what are required. But this is what I could surmise, is that what are the documents required for a trademark? First is the PAN card of whoever is applying, whether it's the chairman, secretary of a trust, whether it's the director of a company, whether it's an individual, whether it's a partnership, whoever is applying, the PAN card is required. And then in the case of firms, okay, not for individuals or joint owners, but in the case of firms, any of the firms, partnership, proprietorship, limited companies, foreign companies, you need a certificate of incorporation. If that firm is not incorporated, you cannot make an application in the name of that firm. So you need a certificate of incorporation. And if you're a partnership, then you need to submit the partnership deed. If you are a limited company, either private or public, you need to give what is known as the memorandum of association as applicable. So you need to give that. And then you need to give all the KYC documents. There's a lot of things to get into this, and I think all of us know banks are pestering us for KYC every 6 months or 12 months or whatever, even if there is no change. And you need to give all the KYC, which includes your Aadhaar card and your PAN card and proof of address and so many various different things. Okay, so address proof. Address proof is mandatory here because the applicant's address may be different from the address of the potential owner of the brand name, of the registered trademark. Okay, so you need address proof and complete details you need of the trademark item, whether it's a word, whether it's a logo, whether it's a soundbite, whatever it is, and the content, whatever it is going to be, with the actual colors and forms. Forms meaning fonts or a scribble or whatever it is. It might be just the swoosh of Nike. Okay, that's why I said forms and not form. But it must be in the actual colors also. Because then that is a logo is generally with actual colors. So these are the basic documents you require, which is a quick checklist. As I said, you might need to give more than this. I'm not aware. You need to check it out with either a good consultant on this matter. I am not the right person to check it out with. I don't know enough. I don't have the domain knowledge. So I hope this has helped you, my friend. This covers both the requests that you've made, and I hope both of them have been helpful to you. I'd love a feedback, not only from him, but from all of you on whether this has been helpful in any way whatsoever. So I will now see you with my next topic. In the meantime, you have a great day. Share this video, share the link with your friends, like the video, subscribe to my channel or pages. I'd want even more people to use that. And please enjoy and have a great time.